All right, let me just start out by saying that in this day and age since COVID, there are a lot of things to talk about. And the fact that we have issues like the rules about wearing masks, whether there can be vaccination mandates, business shutdowns, all these things are landing in the courts and confronting judges with questions of science and government authority. So I think this is a very timely conference to talk about how medicine and law intercede and interact. So under the ABA Model Code of Professional Conduct 1.1, Comment 8, lawyers are required to maintain the requisite knowledge and skill that is necessary to do their job. And their job today in 2020 is a very different job than it was when I finished law school and even in my first 10 years of practice. It changes rapidly, and lawyers and judges need to keep up. To be competent under 1.1a of the model rules, you are required to have the legal knowledge, skill, and thoroughness and preparation reasonably necessary for the representation. The standard of care and emerging technology is changing, as I mentioned. The risks of not being competent in evolving technology: you may make an error when you're representing a client, which could cause harm. Judges may impose discovery sanctions for your discovery misconduct. Professional technological incompetence is not an excuse. There are opinions on that. The inadvertent disclosure of confidential or privileged information is a real issue, especially since COVID, because so much of our exchange has become, if it weren't remotely done in the past, it certainly is done today. Inadvertent disclosures can be forgiven under the rules of professional responsibility, but you have to have taken reasonably prudent steps to prevent that disclosure. There are other issues that involve cyber policy breaches, cloud computing or hacking. There are so many things out there that are just traps for the unwary. One thing I want to talk about too, and this is a formal ABA opinion on it's 498, and it deals with virtual practice. Lawyers may practice virtually. The ethical responsibilities include technological incompetence, diligence, communication, confidentiality, and supervision. Lawyers have the requirement to supervise their own staff, and they need to also be aware of all of the things that are needed to keep the practice in an ethical mode. You have to pay special attention to hardware, software, virtual meeting platforms, smart speakers. They tell me that those Google and Siri speakers are actually listening in your homes or in your courtrooms if you have those in the courtroom. I wanted to mention also that we have so many people appearing nowadays on Zoom and Teams and WebEx and every sort of platform out there. And it's another trap for the unwary. We've heard many stories about people who are not competent in practicing remotely. One of my favorite stories involves the cat in a hearing in Texas, where the gentleman who could not apparently take the meme off of his face said, "I'm ready to proceed, Your Honor, I am not a cat." And the judge, who had blanked his own screen out because I'm sure he was not able to keep a straight face, said, "I understand that." So those are the kinds of things. There are other things that crop up, and you just have to be aware of it. You have to take some effort on your own behalf to actually study this. The benefits of technological competence: it ensures that lawyers will meet their ethical obligations to clients. You have an enhanced work product or presentation. You have to understand how to present evidence in this modern age through remote processes. You have to deal with security guidelines. And in the end, you can actually present a better face to your potential clients through your marketing. Judges also have a duty of technology competence. This is really an issue that we deal with every day, and I think that since COVID, most of the judiciary in Oklahoma has become a lot more technologically competent because we had to. You have to have knowledge of texting. Social media is certainly a trap for the unwary. If you're a judge, there are many ethical issues regarding use of social media, and in some places it's very much discouraged. There is issue with court operations from docket management to courtrooms. These are increasingly in some parts of the country driven by technology, in federal court nearly entirely by technology. Issues that judges must rule on frequently implicate matters of technology. We have issues constantly coming up. We recently had a discussion about the difference between a software developer, a software host, a software provider. If you have an internet company, where is the jurisdiction for any kind of action against that company? Those are cases that are real and out there constantly. I want to mention also that there was a survey in 2019 of federal judges and these are federal judges conducted by a tech vendor. They found that 56% of the survey indicated that lawyers' tech competence in e-discovery matters was adequate. 70% said federal judges should receive more training and education on e-discovery and technology and practices. And I can tell you that if you went to state courts, I'm sure that this would be at least what you would find. Federal judges have significant more resources as a general rule than state courts do. We also have the code of conduct that is 2.5. I want to mention that every one of the model codes I mentioned, whether it be for lawyers or for judges, have been adopted in Oklahoma as well as most other states. 2.5 broadly defines judicial competence as requiring not only legal knowledge but also the skill, thoroughness, and preparation reasonably necessary to perform a judge's responsibility of judicial office. This is especially important when you are dealing with things that you have really not decided to become familiar with. I found an issue in 2008. A judge resigned his position in a city in New York because he refused to use his email account for over 3 years. He had not activated or used a computer provided to him by his Office of Court Administration, and he failed to use the software regarding traffic citations. He was using his own paper form and submitting it, and it turned out that his Department of Motor Vehicles had not accepted his paper forms since 1991. We were in 2018. So there are people who just refuse to learn. I think that's really, and that's hard. It is hard. And I tell young lawyers and law students that I mentor, you are coming out of law school at a time where everything is remote, everything is at your fingertips, everything is in your laptop or your iPad. That's not the way we learned to practice law. We didn't have cell phones, we didn't have computers, we didn't have any of that. So you have to be patient and bring the older generation along, and I think that is a benefit to all of us. Issues in the digital age, when you are dealing with whether the counsel appearing in front of you has done the appropriate security research, knows anything about cybersecurity, has dealt with the issues of hacking, ransomware, cyber stalking, cyberbullying. All these things are extremely important and very prominent. And when you pick up any kind of a publication or online article, these articles are day after day after day. Let's talk a little bit about COVID for a few minutes. That's kind of my overall topic, and we've talked about the remote technology, but let's talk about how do judges react to some of the stresses that we're dealing with. We know that the issues of mental health are skyrocketing in every occupation throughout the country because of the seclusion that we've gone through with COVID. But we found an example of a judge who was at a meeting in May of last year talking with a superior judge, the chief magistrate, who was explaining how they were going to safely reopen their magistrate courts. And this particular person, who was also a magistrate, began asking questions repeatedly in a loud voice. I would say he was freaking out. He started hitting his hands together and going toward the chief magistrate. She tried to calm the person down, but she got concerned for her own physical well-being. The following day, she reported the incident to the Office of Disciplinary Counsel. When he found out about it, he mentioned to a court clerk that she doesn't know who she's dealing with and she will regret that she reported me. Not good. So the state Supreme Court said in that state that they recognized that he had concerns about COVID-19. However, it did not excuse his behavior, and his disruptive behavior reflected poorly on his professional judgment and temperament, and he was sentenced to serve a 6-month suspension and complete anger management training for overreacting to the COVID-19 safety plan in such a disruptive behavior. So I'm sure we're going to see some other situations that develop. I like to say that in Oklahoma, I think that the judiciary are real stars. I think that we were able to maintain work and keep the work of the courts going during COVID-19 shutdown last year. Courthouses may have been closed to the public, but it didn't stop judges from doing the jobs they needed to do. So let's talk about one other topic before I quit this morning. It's been reported that there are at least 24 lawsuits that have been filed as of recently concerning the use of ivermectin treatment for COVID-19. There is reported to be a certain attorney in a Northeast state who's filed many of these same lawsuits on behalf of clients. I've got here on the slide an example of a judge in May of 2021 ruled that in Ohio that a hospital in the region must administer ivermectin, which we know is we call it in Oklahoma the horse pill. I don't know what everybody else calls it in the whole world, but that's what we call it. We call it the horse pill. So using ivermectin and giving it to a patient who is sick with COVID-19 in an ICU, and the judge ruled that the hospital had to provide that. Despite the decision by the medical staff in agreement with recent statements of the U.S. Food and Drug Administration and Centers for Disease Control, the CDC, that ivermectin is not an appropriate treatment and has not been shown to work against COVID. I believe there was some study done that by this group of doctors that is mentioned here, the Critical Care Alliance, where they claim that it is safe and effective in treatment for COVID-19. And the patient's prescription came from a doctor who had no authority to treat patients at a particular hospital, but was licensed to prescribe in Ohio. That's a follow-up to the last slide. And that's going to be the issue that I think that's going to come to courts. And I can't make any comment about anything that's pending or not pending in Oklahoma, but these kinds of issues I think are pretty much going to happen all over the country in state and federal court. But the question then is, what is the ethical issues for the physicians and the legal community? Here we have an out-of-hospital doctor who legally can prescribe this off-label use. There are other off-label uses that I'm sure that everyone in this seminar would agree are appropriate at times, but this is a particular issue that has also become so political. So it is FDA approved for certain things, just not for COVID-19. And we have this intersection and this clash really between the medical and the legal community. So even if it is not approved, certainly a court can order it. So there are some ramifications to all of this, and you know, from the legal side, from the court side, I think that this is a function of education. I think that when a case like this is presented to your community, your medical community, and wherever you're practicing, or your legal community, I think that the important thing is for the judges to be educated about the science. This is not the first time that we've dealt with issues where judges need to be educated about the science. It happens every day in products liability cases, in all kinds of medical negligence cases, I mean, it just goes on and on and on. Intellectual property cases, artificial intelligence cases. I mean, there is so much that the judge has the obligation to learn on their own, but there's also something I think that the medical community can do, the scientific community can do to educate the judge. So in the United States, healthcare providers have a fiduciary duty to act in their patient's best interest, and to directly override the judgment of a treating physician is problematic, but it is not going to be the determining issue for a judge. So I believe that when families try to prescribe or want to require doctors to provide certain kind of care, I saw it mentioned in an article recently that a physician said, when you go to the hospital, you're not going to a restaurant. You don't get to order your own treatments. And I think that that's exactly what the medical community would react to this. But again, it's not necessarily the legal community, because the judge making the decision is probably not going to be a physician, probably will not have medical training. So it is unusual. It might be unusual. I'm going to say it might be unusual for a court to circumvent the medical judgment of the treating physician, but it might not. And I hate to say it that way, but I think that's the reality of the legal system. When it comes to the judge, it's an adversary situation, and the more information the judge has, the less likely that a judge would circumvent the medical judgment of the treating physician. So here's a good question. Do laws requiring the patients be offered access to unapproved drugs through the FDA's compassionate use program apply to the situations where patients are demanding administration of an unauthorized drug? Dr. Sandbar has educated me on a number of these issues that I had not really, probably before this seminar, understood the viewpoint from both sides on this issue. Because what you see in court is you have someone who is asking for the drug, and then you have someone who is saying that my family member is dying, and there's no other treatment that's going to work, and if you don't administer this drug, my family member is going to perish. And of course that puts families in a terrible situation, because then they're trying to do the best they can. They may believe the science, the other side of the science that they've read about and don't really understand all of these things. There are also politicians who are making comments on this. We reported in, I believe, some materials that you may see in Nebraska. The Attorney General has said that no physician will be disciplined for prescribing or using ivermectin or hydroxychloroquine. I always try to say that wrong, hydroxychloroquine. And that's been around too for a number of months that we've dealt with. So ivermectin is not the first time that something's been brought up. But when you have political statements being made around the country by people who are in law enforcement or in high positions in government, that they are trying to protect the medical community so that the medical community can use these off-label drugs, it becomes extremely complicated for judges. And so just so you understand, in many of these cases, the Attorney General of the states will be intervening and will be actively asserting the right for people to have choices. And there will be governors, there will be other people that are making these comments and are making these comments now. And again, I'm making no comment on any of this in terms of who's right and who's wrong, but these are issues that everyone has to think about. This was brought to my attention that there are actions that are available against doctors who spread false information about COVID-19. There's the Federation of State Medical Boards, the state licensing boards, federal and state medical associations, medical ethics, employers, and then there are other issues that come up also that have to do with First Amendment and free speech. So there are going to be a number of these things that are litigated. I don't know the outcome of these things, because I think it's going to depend from court to court. I would recommend that in the event that a hospital is being sued, to force the administration of something that the doctors and the hospital believe is unethical or is in violation of their oath, that they get involved in the case. It may be that the hospital needs to have someone else intervene, maybe the State Medical Association. We've mentioned here the federal and state medical associations. There is a procedure to go into court and ask to intervene. If there is something being presented to an appellate court, amicus briefs are always welcome. And those are the kinds of things and the tools that are available in order to help the medical community educate the judges and the appellate judges. And again, I cannot give you an outcome. I can't provide you with anything that is specific in terms of, I'm not seeing a lot of reported cases yet, other than a few where doctors are being ordered to provide medication. I might also add that in those cases that I've read about, the patients survived in each of those cases. So from a standpoint of how do you discourage people from asking for that medication when you find out that the patient that was given the medication survived COVID-19? Now, would the patient have survived otherwise? Those are questions that I think have to be presented in a scientific way to the judges who are hearing those cases, because you would think that, it would seem to me that that would just add more sort of fire, more fuel to the fire. I believe that, is my time? I need to round this down. Okay, so I'm going to